Hi, welcome to Pennsylvanians for Modern Courts programming on the courts and the legal system. I am Deborah Gross, PMC's CEO. I would like to thank you for being with us today. Our programs are designed to help you understand the importance of the courts, their impact on you, and their fundamental contribution to our democracy. Our goal is to provide you with resources to navigate the courts with confidence and understand your rights. After a long career in private legal practice as a litigator and as a passionate advocate for the nonprofit legal community, I pivoted to advocate for increased awareness about and access to the courts. Judicial independence is the cornerstone of our democracy, and the public's attitude towards and confidence in the judiciary has shifted in recent years. We hope these programs help you understand that judicial decisions are made based on Constitution, statutes, and the law, and not public opinion. Please visit our website, www.pmconline, that's Paul, Mary, Catherine, to learn more about PMC and find an abundance of resources on the courts. Thank you for listening, and let's begin tonight's program.
Thank you. All right, so I'm Carol Sikov-Gross, and I'm an attorney here in Pittsburgh. And basically, we first want to just give you some terms. So this is the Register of Wills. And the Register is also known as the Clerk of the Orphans Court. There are 67 counties in Pennsylvania. Basically, every other county has a Register of Wills except for Allegheny County. We're just a little strange. We have the Department of Court Records. And we changed that several years ago. So the Register of Wills in most counties is an elected official, and this is where we go to open estates and deal with other matters having to do with the state administration. So people are always like, well, what's an estate? An estate is when a person dies and they have assets in their own name that don't have joint owners or beneficiaries. That's when we need an estate. We need to open something at the Register of Wills office so that someone can handle those assets. And probate, which many people want to try to avoid, is the process of opening that estate at the Register of Wills office and having an executor or an administrator appointed. And people are like, oh, but Carol, I heard you want to avoid probate. Well, the reason people are concerned about avoiding probate is they're concerned it's going to take a long time to open an estate. But generally in Pennsylvania, an estate can be opened up in about an hour to 2 hours. If you have an original will, you have an original death certificate, and you have the person who you're going to appoint. In some states, it can take months and months and months to open an estate, which is why people want to avoid probate if they live in places like Florida, California, Arizona, New York, New Jersey. Okay, you want to go to the next slide? Okay. So when do you need to open an estate? You only need to open an estate if the decedent had assets in their own name when they died. So, when we look at it, we want to see what did this person have. If they had a joint bank account, let's say with their spouse, or they had a joint bank account with a child, and that was the only asset they had, we would not need to open an estate because that joint asset would pass to the surviving joint owner. If the only asset they had is a life insurance policy with a named beneficiary or a small retirement account with a named beneficiary, those things are going to pass to that named beneficiary. And again, we won't have to open an estate. There will still be things we need to do, but we will not have to probate a will or something like that. So here we talk about what types of assets there are. So we could have real property, a house, land, a family campground or whatever. Personal property is going to be things such as bank accounts, cash, your furniture, your clothes, your purses, your jewelry. All right. So some of this property, if it's in the decedent's name alone, can only be transferred. We can only deal with the transfer of ownership going to open an estate. And the non-probate property is anything joint ownership or things with named beneficiaries that will pass outside and not be controlled by the will. All right, let's forge ahead. So here's a nice little flow chart that can help you understand this. So you see the first question is, did the decedent own any property? And if they didn't own anything when they died, you don't have to worry about opening an estate because there's nothing to deal with after they're gone. If they did own property, but it was all owned jointly, again, you wouldn't need to open an estate. Say they didn't have any jointly titled property, but everything had named beneficiaries. It was life insurance or retirement account. They put on their bank account a transfer on death owner or on a U.S. savings bond. And if everything is going to pass to named beneficiaries, again, you would not need to open an estate. But if all those things are no, then you get to the end and you need to open the estate. So this little picture can help you understand when you would need to open an estate. All right, let's forge ahead. So the next question people are like, well, can I open an estate on my own or do I have to have a lawyer? You do not have to have a lawyer to open an estate. You as an individual could go into the Register of Wills office and get the paperwork from them and try to open the estate yourself. The clerks in the registrar's office are not allowed to give legal advice. So the problem is that you're going to have questions. You're going to want to know about time frames, things like that. When am I supposed to do things? And this is why it can be extremely helpful to have an attorney to assist with the estate administration. And at the Register of Wills office, they will most likely suggest that you have an attorney. Neighborhood legal services can provide some assistance, but if there's assets in the estate, you may have to contact the county lawyer referral service. Like here in Allegheny County, we would contact the Allegheny County Bar Association lawyer referral service to get an attorney to help assist with the estate administration. Sometimes people will work with the attorney who drew up the will for the decedent. And I will say I have been involved in estates where people got into it themselves, and then they suddenly realize several months later that they don't know what they're doing, and they look for legal advice. And attorneys can help you as you move forward, but it's better to do it at the beginning so that you make sure you're handling things properly, because there's a lot of time limits. Things have to be done at a certain time, and if you do it yourself, you may not make all of those. And the reason that you want to make sure you meet all the deadlines and you do things when you're supposed to is that the executor or administrator can be personally liable if they don't do things properly. And that's why it's for your protection as the executor or as administrator to hire an attorney. It is paid for by the estate, and it's there for your protection. Okay, next slide. Okay. But I must make a disclaimer now. This is what I've been told I need to do. I am not your attorney by virtue of this presentation, and I'm not giving legal advice to you. All right, I'm giving you general information to understand how the process works, but I am not representing you. So just be aware of that. So the probate process, I mean, I go through it and work on it every day. So I think it's pretty easy, but it can also be difficult and dangerous for people doing it on their own, simply because they're not aware of all the things that they may need to do, the timeframes they may need to meet, and that's why it's a good idea to have legal representation. All right, please go right ahead. Okay. Now, these are some of the issues that, when people are trying to do these things by themselves, they can run into problems with. So one of them has to do with the payment of creditors. Why? Well, some estates, believe it or not, are insolvent, which means you have assets and you have debts, and the debts are far outweigh the assets. So the estate's insolvent, and the money that you have has to be split among the creditors. And there's a certain priority as to how things get paid. And if you don't pay them in the right priority, the executor or administrator can get into trouble. All right, so we're going to talk a little bit more about that as we go forward. There can be, stay on that slide. I got other things to talk about. Okay. Also, now, another problem that can occur is if you have a decedent who was on Medicaid or medical assistance, maybe in a nursing home, and money is going to be owed back to the Department of Human Services for the person's Medicaid expenditures. And that has a certain priority as where it goes. And if you don't pay them when you're supposed to, the Department of Human Services can come after the executor because it is the executor's responsibility to notify them that a person on Medicaid died and to request a statement of claim. If you don't do that and you don't see what you're going to have to pay and then potentially pay it at the appropriate time, priority, there could be problems. Okay, we're going to talk about inheritance taxes, because in Pennsylvania, when people inherit something, they have the privilege of paying a tax to the Commonwealth of Pennsylvania. And certain people do owe taxes, whether it's children, siblings, anybody else. Spouses are fortunate that they do not have to pay inheritance taxes because the rate for them is 0. Okay. And then, all right, what other problems? We could have problems with expenses. Who pays what expenses? Does this come out of the estate? Is this paid by the beneficiary of a retirement account? Do they pay the taxes? That's a good question, and that's why sometimes you need advice to help with that. And then finally, to make distribution of the assets at the end of the process, because you have to make sure that if the will says I have 10 people who are each supposed to get 10% of the estate, I can't give somebody 15% or 20% because I like them better. I have to follow the terms of the will and give them what the will says, or give them what Pennsylvania law says they are to receive. And so we have to be careful so that the executor can be personally responsible for making mistakes. All right, now we'll go ahead. Okay. All right, so 2 types of estates. We have a testate estate. This is where a person has a last will and testament, and the will determines who is to receive the decedent's property. A will usually will name an executor or an executrix, somebody who will administer the estate and control the distribution of those probate assets. Or if somebody dies without a will, they don't have a testamentary document, then state law determines who has the right to be appointed as administrator or administratrix of the estate. And there's a priority as to who gets appointed. So first it would be a spouse, then it would be adult children. If you have a second marriage situation, sometimes the spouse and the adult children from the first marriage can have an equal right to serve. After that, it goes to parents, then it goes to siblings. So there's a whole priority as to who gets appointed. But if nobody else wants to be appointed, eventually a creditor can even be appointed to administer an estate. You have to be competent to serve, which means that you couldn't be a child under the age of 18 because you are a minor, you're not competent to serve, or somebody who is suffering from dementia. My spouse would normally be supposed to be appointed, but they're suffering from advanced Alzheimer's disease. They would not be an appropriate party. If you have a spouse from the second marriage and you had, say, 2 children from the first marriage, all 3 of them have the right to serve. Some of them can renounce. So the 2 children could say, well, we trust our stepmother and she'll do the right thing, so we're going to renounce our right to serve. Okay. Now, when you die intestate, state law determines how the property is distributed, because you don't have a will that determines that. Okay. All right. Let's forge ahead. Okay. All right. Oops, it's popping up here. So now we have, okay. We have joint accounts. Those are going to pass to the surviving joint owner. They are still subject to Pennsylvania inheritance tax. But usually if the account has been joint for at least 1 year, the tax is only on 1/2 of the balance. If it's owned by 3 people, 1 person dies, it might only be on 1/3 of the balance. But that's the joint assets. Beneficiary designated assets can also be subject to inheritance taxes, not life insurance, one of the few things that's not subject to tax, but money that goes to, children, grandchildren, whoever it is, of your retirement account, of your transfer on death investment account or bank account, or on a savings bond, something like that. And then we have our probate estate, and those are the assets that the will controls to determine who's going to receive them. There can be specific gifts. So you could say in your will could say, I leave $10,000 to everyone who is on this Zoom call tonight. Okay. And then everything else is divided by my 2 children. That would work. Okay. That's the residuary of your estate. It's whatever's left after paying specific bequests. But if I passed away and all I had was $30,000, for example, that would pay the 3 specific bequests, and my residuary heirs would not get any money. I want you to also know that gifts made within 1 year of death. So if I'm on my deathbed, oh, I'm dying, and I give away all my money, that money will still be subject to inheritance taxes because the Commonwealth of Pennsylvania does not want people on their deathbed giving away their assets to avoid Pennsylvania inheritance tax. Okay. All right. Forge ahead. Yeah. Okay. So let's just go through some terms here. All right. So we have the executor named in the will, all right, who's going to open up the estate, or if there is no will, again, it would be the administrator, all right, and they have to gather together the executor would gather together the original will. You have to probate the original will. And all probate means is taking the will into the Register of Wills office and filing it of record. So if you said to me, Carol, my next door neighbor died 5 years ago, can I go to the Register of Wills office and see their will? You could, if it was probated, because it's a matter of public record. Okay, the only will that I know of that has been sealed, where you can't look at it, is the late Senator Hines. His will was sealed. Okay. What gets submitted to the Register of Wills office? The original will, a death certificate, you have a estate information sheet, and a petition for grant of letters. You have to pay a fee to open an estate. And right now, if you have an estate of around $100,000, the fee would probably be about $200 to $300, but you have to pay that. And you have to bring your photo ID to the registrar's office so that they know if you are named in the will, they know that you're in fact that person. Okay. If it's an estate administration, you obviously would not have the will, but you need all the other documents. Okay. You go in person to the Register of Wills office in the county where the decedent resided. So if somebody died in Allegheny County, they would come down to the city county building to get the estate opened. We do now in Allegheny County and in many other counties around the state do permit what's called remote swearing in. And this is something that varies county by county. In Allegheny County, you schedule this ahead of time. The court clerk calls in. You can do it online, but you have to follow whatever the local county rules are. Normally the lawyer has to be on the Zoom call. Somebody at the Register of Wills office, the person who's getting sworn in, and they have to actually do the signing on the computer and swear in that way. Otherwise, you go into the registrar's office and you get sworn in. You raise your right hand. And probate can be done anytime after the person has died, but you have to have the death certificates. And now, since COVID, it used to be much quicker, but now it can take anywhere from 1 to 2 weeks before you can get the death certificates. All right, we'll forge ahead. Okay. All right. Finding the original will can sometimes be challenging. Sometimes it is the decedent had it in their own possession. Sometimes it might be in a safe deposit box, and you'd have to go and have the bank do a will search of the safe deposit box. The will might be with the attorney who drew it up, and normally they would be contacted by the person who's named. Hopefully, the decedent told the person, "Oh, by the way, Mary, you're the named executrix under my estate, and when I die, it's in my safe deposit box, or my lawyer has it. Please call Carol and ask her for it." Okay. If there's no original will, then you sometimes have to determine who the next of kin are. So that would be a spouse. First, look for a spouse, then you look for children, then you look for grandchildren. If there's nobody in those groups, you go up to the parents of the decedent, then out to the decedent's brothers and sisters, nieces and nephews. If there's still nobody, you go up to the grandparents' generation. Grandparents are deceased, you look for uncles and aunts. So you basically, it's an upside down tree. You go up and out to try to find somebody who's to serve as the administrator of the estate. You get the certified death certificate from the funeral home. The petition for grant of letters and the estate information sheet you can obtain those at the registrar's office. You can obtain them online. and that we're going to get there. That's it is on another slide or two. Or the attorney can prepare them for you, and then you bring your photo ID to get sworn in and take your oath. Okay. The clerk at the county register of wills office will keep the original will, keep the petition for grant of letters, the estate information sheet, the check. They won't keep your driver's license. You get that one back. Okay, and these fees vary by county. All right, forge ahead. Okay. All right, so here's a copy of an estate information sheet, and this indicates where you can obtain this cover sheet. And it's used for both testate and intestate estates. And it is a statewide form used in some counties. We don't usually use it in Allegheny County, but the surrounding counties often do. So this form is just asking for information about the named executor, the decedent, and then some information about if the person died intestate, about potential heirs. Okay, you can go to the next page. And this is the petition for grant of letters. It's grant of letters of administration if the person died without a will, and for letters testamentary if they died with a last will and testament. And this is a 2-page document. It is filled in with information about the decedent, about their will, about the heirs if there is no will, the name and address of the named executor, information about the attorney. It asks, are there any minor beneficiaries? Will a bond be required? Bond is an insurance policy that's there to protect the estate if the executor or administrator runs off with all the assets. And then there's a column there which is showing for numbers. There's a cost for filing this. And so there's you make some choices as to what kinds of things you might need. And again, this form can be found online at the Orphans Court Forms on the Unified Judicial System, and there's an address for that. Okay, so go to the next page, please. Okay, so after an estate has been opened, all right, and the will has been probated or the letters have been granted of administration, okay, and this talks about letters testamentary and letters of administration. And what is issued by the registrar's office is something called a short certificate. Now, a short certificate actually used to be a short piece of paper. Nowadays, everything's printed on computers, so it's a regular size sheet of paper. It's usually, in Allegheny County, it's parchment-y, and they put a seal on it so that you know it's an official document, that you have been appointed as an executor or administrator of an estate. And this is what is needed to show proof that you are appointed. And a lot of times people will call me up and they'll say, Carol, I need to close out my mom's bank account. I need a short certificate. You can't get a short certificate unless you open up an estate. Okay. The short certificate gives the executor or the administrator the authority that they need to collect the decedent's assets, to pay the decedent's bills, to open an estate checking account, and eventually distribute assets to the heirs of the estate or the beneficiaries. So it's basically a piece of paper that gives you a lot of authority, but you have to have that to serve as an executor or as an administrator. Okay, go ahead. All right, so these are, in a nutshell, the steps, and we're going to talk about them in more detail. Okay, we're getting sworn in and we're obtaining our letters or short certificates. Now, the next step is going to be providing notice, and we're going to talk a little bit more about that, because it used to be years ago, there was no requirement under the law that you had to notify the beneficiaries. So if you decided, gee, my cousin Sally is a beneficiary, but I don't like her, so I'm not going to tell her that my mom left or something, that would happen. So now you're required to give notice, okay? You have to advertise an estate. It has to appear in 2 papers. One is the legal journal in the local county, and then the other is a paper of general circulation. And the reason that you're to do this is creditors have the right to know that a person has died, so they can make their claims. Okay. All right. You have to get an employer identification number from the Internal Revenue Service. You cannot, after a person died, use the decedent's social security number. It dies with them. But I always tell people to be very careful. I've had estates where people, again, try to do these things themselves, they try to get an employer identification number, and they end up on a fake IRS website, and they end up paying a couple $100 for this employer identification number. We usually always get them for clients, and that's what usually lawyers will do. It's free. The IRS does not charge for granting an employer identification number, so that's why you have to be very careful. Okay. I just wanted to warn people about that. You also have to, as the executor or administrator, identify the assets of the estate. Usually we'll open an estate bank account because it's like setting up an estate is like setting up a business, and it needs its employer identification number. It needs its own bank account. We're then going to worry about looking at debts and prioritizing them to see what debts we may be able to pay, what debts we may or may not be able to pay. The estate has to file an inventory of assets, and these are probate assets, the things that the decedent owned at the time they died. No not joint assets, not beneficiary designated assets, assets that are controlled by the will or state law. We also have to file tax returns, and this would be a Pennsylvania inheritance tax return, again, usually done by the estate attorney. Federal estate tax return. Well, you have to file a federal estate tax return if you have an estate in excess right now of $12,900,000. If you have that kind of money and you're trying to do this without an attorney or without an accountant or without somebody to help you, I would strongly recommend you don't do that, because if you have that type of money, you can afford to pay for some help and make your jobs a lot easier. There's also an estate fiduciary income tax return, because an estate, since it has an EIN number, has to file a tax return to reflect any income or deductions that it may have. Okay. When we eventually go to close out an estate, we're going to do this by either a formal accounting in the court, and we'll talk a little bit more about that, or by a family settlement agreement, where the family members agree that we're going to discharge my brother Bill from serving as the executor of the estate. Everything's in order, and we're going to let him go. Most estates in this area are done by family settlement agreement, but you sometimes have to do accountings when you have minor heirs, people who are incapacitated as beneficiaries. You have an insolvent estate and all the creditors are not going to get paid. Or you have a family where people don't get along. And believe it or not, sometimes families fight and they don't get along and they won't sign a family settlement agreement. All right, the executor will then, after this is done, eventually distribute assets and close the estate. So those are kind of, we're going to talk now in more detail about some of these options. All right, forge ahead. Okay. All right. So we basically, if we have a will, we'll know who the heirs are. Okay. I named my 3 children as the beneficiaries under my will. I've now passed away. They would get notice of the estate administration. If God forbid, one of my children had died and they had 2 children, we might have to give notice to those people because now they're taking the deceased child's share. All right. If person died intestate, we're then looking at the heirs under law. So the way it works with heirs under law is this. The first heir, it would be a spouse. That's the first person we're going to look for. Then we're going to look for children of the decedent. So if you have a spouse, it's a first marriage situation, the spouse would get the first $30,000 of the estate and half of the balance, and the children would get the remaining half. If it's a second marriage, so the children are from the first marriage, the spouse gets half and the children divide half. So it may or may not be what somebody would want, which is why people should have wills. All right. The notice of estate administration has to estate administration has to be sent within 60 days to the beneficiaries and the heirs, so they know that they are an heir. It doesn't indicate to them at this point what they're going to receive. Usually it's a good idea to attach a copy of a will to the notice so that people see the will and they see what they may have been left. And then you have to file a certificate of notice at the Register of Wills office to indicate, yes, I have in fact given notice to the heirs. They know what's happening. Okay. We also advertise the estate. And again, this is to let creditors know that the decedent has died, and if they have a claim against the decedent owes them money, they have to file their claim within 1 year of the date of advertisement. Advertisement appears once a week for 3 weeks in the paper of general circulation and in the legal journal. Okay. All right. And okay, so, and they have 1 year to do this, and they can, I mean, you want to make sure that you deal with that and they're covered. All right. Next slide, please. Okay, so this is the notice form to let the heirs and beneficiaries know about the estate administration. It's got names and addresses on it. And these forms are pretty much used statewide, but they may vary a little bit county to county. And again, we've given you an address for where this form can be found. Next slide, please. Okay. So here it talks about the legal journal of the County of Administration. So if we were in Allegheny County, it would be the Allegheny County Legal Journal. General circulation would be the Pittsburgh Post-Gazette. And you can contact the estate advertising department to do this. Okay. And basically, as I say, it runs once a week for 3 weeks, and creditors have 1 year to file their claim and at the Register of Wills office. Okay, next page. All right. Now we're going to be identifying assets. Okay, so basically we're looking for things like bank accounts, brokerage accounts, certificates of deposit, savings bonds, all kinds of things. And you would check the decedent's mail, you would look on their tax returns, you look around their house, see, I find savings bonds laying around. I will tell you, it used to be easier to find these things because there'd be mail, and they would be in the mail, and you would find mail, and you would gather these papers. But now a lot of people do things online, so it makes it a little more challenging to try to find the assets, because somehow you need to have access to their computer to be able to check, because they did online banking. So just be aware. You also want to check for unclaimed property on the PA Treasury website. If the person lived in another state, you might want to check their unclaimed property as well, because they might have some checks and things sitting around to be claimed, and that's also going to be part of their estate. You want to be closing out the decedent's accounts, putting the money into the estate account. That's your business account. Close credit cards, and you have to give notice to these people and let them know that they died, they can make their claims. For assets, you want to determine the date of death values. So what was this account worth at PNC at the date the decedent died? Not PMC, but PNC, or Citizens, or wherever it is. You want to find out on credit cards the date of death value there as well. What did the person owe when they died? They are not allowed to charge late fees or interest after someone passed away. So you want to only use the number as of the date of death. Normally, you're going to open an estate checking account, and you'll use your employer identification number for that, and that's where you'll be conducting the estate business. Usually, the attorneys for the estate will want to maintain the estate checkbooks because they need to be able to keep track of all the monies in and all the monies out of the estate for later distribution and to account to the court. You don't commingle these funds, so you would not ever put the funds from the estate in your own personal bank account if you were the executor. This would be in the, oops, where'd you all go? This would all be in your estate account. Okay, now, one of the things that also needs to be done is we need to prepare an inventory of the estate assets. So the inventory is going to list the probate assets. It would list the bank accounts, PNC, Citizens, Dollar, Key Bank, S&T, whatever it is. It would list where the brokerage accounts were. It could list household furnishings and personal effects, the decedent's car. It could list other types of personal property, jewelry, things like that. These are the types of assets that are going to be passed through to beneficiaries. The inventory gets completed and filed within 9 months of the date of death, and you file 2 copies at the Register of Wills office. All right, go to the next screen, please. Thank you. And this is a copy of the inventory. It is signed by the personal representative, by the executor or the administrator, attesting that this is correct. Sometimes if you find an asset later, we had this happen in an estate where several months later, when they were cleaning out the basement, they found a lot of savings bonds, and we filed a supplemental inventory. But again, the form is there. You can go online to the Orphans Court forms and use this form. It's used statewide. Okay, next. All right. Okay, now we're going to talk about taxes. Okay, there's a lot of taxes with a decedent's estate. All right, we'd have the decedent's final income tax return. So if a person passed away today, they would still have to file a 2023 income tax return. It won't be filed until April 15th of 2024, federal, state, and local for the year of death. The Pennsylvania inheritance tax return is due within 9 months of the decedent's date of death. And this indicates the assets of the estate, so the probate assets. It would also list jointly titled assets, because they are subject to inheritance tax, and assets that have named beneficiaries. They are also subject to inheritance tax. Now let's talk a little bit about inheritance taxes. So Pennsylvania inheritance tax for spouses is 0. For children, grandchildren, parents, anybody in the line, lineal descendants up or down, it's 4.5%. However, if you have minor children or grandchildren who are under the age of 21, the Pennsylvania legislature had passed a couple of years ago saying no, minor children do not have to pay Pennsylvania inheritance tax, which was very nice. Everybody else does. If your siblings, if you leave money to siblings, brothers and sisters, again, that's a 12% inheritance tax. And to anyone else, nieces, nephews, cousins, my friend Joe, whoever it might be, they have to pay inheritance tax at 15%. If you left money to charities, nonprofits, churches, the Humane Society, the Pennsylvanians for Modern Courts, whoever it is, that there's no tax on any money you leave to charity. The tax rate is 0. Okay. The inheritance that the beneficiaries are receiving are usually not income to them. They are inheriting principal. There might be a small piece, somebody inherits a CD, and there might be some interest that they get with that. That is income. Okay, but everything else, the bulk of the CD is not, it's just principal. Most assets are going to be subject to inheritance tax, but there is one interesting exception. If you die prior to 59 and a half and you leave your retirement accounts to people, they will not have to pay Pennsylvania inheritance tax on them. So if you die young, under 59 and a half, you would leave a good looking corpse and your heirs will not have to pay inheritance tax on your retirement accounts. But I don't think it's a good reason for doing so. All right, federal estate tax. Again, this is only for people right now who have an excess of $12,900,000. And federal estate tax, you're talking somewhere a tax at around 40%. So most of us don't have to pay that. The estate fiduciary income tax. Again, we set up this business. The business has in operation for some period of time. We're going to have to file a fiduciary income tax return. A state usually does not pay income taxes. It usually will pass the earnings and the deductions through to the beneficiaries on a K-1. Now, I do want to mention this. This tax return is due, the inheritance tax return is due 9 months within someone's date of death. If, however, you need an extension, you can get a one-time extension for 6 months. Okay. And then if a decedent, okay. All right. And this is where it talks about income in respect of a decedent. If a person leaves a retirement account and you inherit a retirement account from them, aside from a Roth IRA, and they are over 59 and a half, there will be inheritance taxes due on that retirement account, And you as the beneficiary, as you pull that money out, and for most people, they will have a time limit of up to 10 years, not spouses, but anybody else. They have to take that money out over a 10-year period, and they would have to pay income taxes as well as the inheritance tax on that retirement money. Okay, let's go to the next slide. Okay, now we're talking about our deaths. So this is where it's important for the administrator or executor to prioritize the debts of the decedent. Make sure, what are they going to be able to pay? Administrative expenses have the highest priority. Administrative expenses include the costs of opening up the estate, the executor or administrator's fee, attorney's fees, bills and things that you have to pay to administer the estate. That might include an appraisal of a house or appraisal of jewelry. It might include paying for a survey on a piece of real estate, the advertising expenses. All of these things are administrative expenses. And the reason they have the highest priority is the state wants to encourage people to administer decedents' estates, so they allow that to be paid first. The second priority is something called a family exemption. So if you are a child or a spouse who lives with the decedent, and you're entitled to a family exemption of $3,500 for providing care and services to the decedent. It's a deduction and it gets paid second. The third exemption, the third deduction are funeral expenses and burial expenses. So this is money for the funeral, grave opening and closing, a monument or a marker, a funeral luncheon or wake, postage for thank you cards, flowers, money for a religious person to officiate at the service. So those have the next priority. The next thing are medical bills incurred within 6 months of death and Medicaid charges incurred within 6 months of death. So those things are the next priority. Grave marker comes after that for the cemetery, but usually the Department of Human Services will allow people to pay for the grave marker before paying Medicaid, which is very nice of them. Rent of the decedent due for the last 6 months. Okay, so if the decedent had an apartment, they hadn't paid their rent, that's the next priority. Claims of the Commonwealth. Now, this includes money that you owe to the Commonwealth, including money you owe to for Medicaid or the Department of Human Services. If a person had been in a nursing home for like 1.5 years prior to their death, the last 6 months before their death would be priority number 4, but the rest of that year's bill would have to be paid back potentially, and that would be a lower priority claim. And then all other claims, including credit cards, they get paid last. So when we have an insolvent estate, we have to determine, okay, I can pay all the administrative expenses, I can pay the family exemption, I can pay the burial expenses, but I only have, X number of dollars left to divide among $40,000 of medical bills. And then they're each going to get so much on the dollar. So, but that's where you need help sometimes to determine that priority and how you're going to make these payments. All right, let's go to the next one. Okay, so we've done our job. We've collected the assets. We've paid the bills. We've paid the taxes. We're now ready to, and what happens is once you file the Pennsylvania inheritance tax return, it takes the Department of Revenue approximately 6 months to review the return and give you a notice of appraisement, telling you that they've reviewed it and accepted it. The estate cannot be closed and should not be closed until you get that clearance from the Department of Revenue. Okay. Because you want to make sure that you're going to have enough money. Everything has been paid that needs to be paid, including an executor's commission. This is an amount that can be paid to the executor or an administrator. And usually this can be paid on a percentage basis or an hourly basis. And also there's attorney's fees that should be paid. And again, that can be on a percentage basis or on an hourly basis or some combination thereof. So again, this is something that is there to help their deductions that can, those fees would come off the help save taxes, but those again would need to be paid before you complete the administration. So you're going to distribute assets pursuant to the terms of the will, and then the intestate heirs would get it under law. All right, you want to go to the next page, please? Thank you. Okay. We also have to distribute real property. It does not pass automatically when the person passes away unless the property is joint tenants with right of survivorship, or tenants by the entireties between a husband and wife, or you have a deed that says a person has a life estate and there's a remainder beneficiary. So this is why, and people oftentimes, when people try to administer estates themselves, they sometimes don't deal with the real estate. So years later, you can have a house that's still in grandma's name, even though grandson is the one living in the house and thinks he owns it. So this is where deeds need to be prepared. Again, and this is usually done by attorneys. If the executor wants to buy the property from the estate or receive the property from the estate for their fee, they might need court approval to do that. When we're transferring estate property, it's either done by a decree of the court or by the preparation of what's called a fiduciary deed. A fiduciary deed doesn't have the same language that a general warranty deed would have. If I'm selling my house to you, I'm going to use a general warranty deed because I've lived in it. I can guarantee all the information. The executor or administrator is not held to that same standard, which is why it needs to be a special type of deed, this fiduciary deed, so that the executor or administrator is not going to be responsible for things they shouldn't have to be responsible for. Okay. All right, so we're getting ready. Going to go to the next slide. We're almost ready to do our administration. Okay. Okay, so we can do this normally several ways. We can do it by a family settlement agreement between the family. Everyone signs off on it. They understand that this is the estate was administered. These are the assets that went in. These are the disbursements that were made, and here's what's left for distribution to the beneficiaries. They sign the family settlement agreement, or they can also sign something called a receipt and release to basically say, okay, I understand the estate was insolvent, and the only thing I'm getting is the car because that was, that was specifically left to me, and the rest of the money went to pay all the creditors. That might happen. All right. If we don't do it by a family settlement agreement, we can also do it by what's called a full accounting. And this is where an accounting is prepared, detailing everything that happened and when it happened. It's filed with the court along with a petition for disbursement. And the court takes us to what's called an audit. It's reviewed by the court or their court clerks to make sure that everything adds up, makes sense. If people want to object to it, they can file objections to a formal accounting. And again, this can happen where the family doesn't get along or where the estate's insolvent. And then the court issues a decree. Once the court issues a decree of distribution, it has to wait 30 days to become final, and then distribution can occur. But people can file objections and things like that. You can also file, if you have a small estate of less than $50,000, you can do a petition to the court to settle a small estate. And so you want to make sure that if you're going to go to a formal accounting, you have to give notice to the beneficiaries, you have to give notice to creditors who were not paid their claims in full. And so you want to make sure you wait and give the advertising 1 year to pass. Okay, next. Okay, all right. So once we've transferred our real estate, we have distributed our assets, either pursuant to the family settlement agreement or the accounting. We file a status report to indicate the estate administration is complete. They are to be filed every 2 years. If you have an estate that for some reason continues on for longer than the usual time, most estates take anywhere from 15, 18, 24 months. That's about a usual time. Some estates can be done a little shorter. Some estates might take a little longer. Sometimes you have an estate with real estate you can't sell, and that could drag on longer. If the estate administration is not complete, you have to indicate it on the status report, and then you'd have to file more within the next 2 years. And again, this is a statewide form that you can obtain online. So basically, an estate administration is something that it's not a bad process. I know it sounds like a lot of steps, but if you do this, if you have assistance, the attorney can help you get through this process and basically give you the time to grieve, deal with what you need to deal with, and you can get help. If you do this yourself, just remember you have deadlines and things you have to meet, and be careful because of the personal responsibility. All right. It was thank you for being an audience, and thank you for participating in this program. And please support Pennsylvanians for Modern Courts. They do a very nice job.